Victor Oko-Jumbo-led Rivers State House of Assembly, loyal to the state governor Siminalayi Fubara, has dismissed the resolution passed by the Martin Amaewhule-led Assembly, which barred the governor and the state government from withdrawing money from the Consolidated Revenue Fund of the state. Speaking before the commencement of sitting in the Government House, Port Harcourt, on Tuesday, Oko-Jumbo said Amaewhule and the other lawmakers who defected from the People's Democratic Party to the All Progressive Congress have lost their seats, describing their sitting as illegal. Oko-Jumbo said their seats were declared vacant on December 13, 2023 by Edison Ehe, the then duly recognized Speaker of the 10th Rivers State House of Assembly. This was contained in a statement issued by the factional clerk of the House Assembly loyal to the state governor, G.M. Gillis West, on Tuesday. Oko-Jumbo said it is laughable to have heard and seen the news of the illegal sitting of the 25 former members of the State House of Assembly, led by Amaewhule, on television and social media space on July 15, 2024. Recall that the Amaewhule-led House had, during plenary on Monday, passed a resolution to the effect that Fubara is not permitted to authorize the withdrawal of money from the Consolidated Revenue Fund of the state. Amaewhule also threatened a shutdown on expenditures until an appropriation bill for the 2024 fiscal year is presented to it by Fubara for consideration. The pro-Wike lawmakers' resolution directed the governor to desist from further authorization of withdrawals from the Consolidated Revenue Fund of the state, while directing all state government ministries, commissions, agencies, departments, and extra-ministerial departments to desist from spending taxpayers' funds until the 2024 appropriation bill is laid before the House. But Oko-Jumbo, according to the statement, insisted that only recognized state legislature currently in the state is the one he presides over. He also said that the governor presented the 2024 appropriation bill to the Rivers State House of Assembly under the leadership of the then Speaker, Right Honorable Edison Ehe, and it was duly passed on December 13, 2023, and assented to on December 14, 2023. Forgiven, what is your take on this issue?
2024 is already coming to an end. We are entering into 2025. And we are not operating retrogressively, we are operating progressively. As at when the 2024 budget was presented to the Edison Ehe-led State House of Assembly, Edison Ehe was the Speaker, duly recognized by a court of competent jurisdiction. And whatever he did while that declaration by the court of law subsisted remained valid. And calling for re-representation of a budget at over the middle of the year, when we should be thinking of another year, to me is a call for lawlessness, and it should be resisted. I am in total support of what the Speaker of Rivers State House of Assembly, as led by Right Honorable Victor Oko-Jumbo, said that the 2024 appropriation bill has been duly approved and assented to by the governor. And any call for representation is unlawful because a duly recognized and constituted House of Assembly had done that already, as at when that decision was taken, as at when that budget was passed. Edison Ehe was the Speaker.
All right.
So any further call for representation, what was happening before now, that people were even listening to a representation, was when there was an attempt for political mediation, settlement by intervention by the president. And it was made clear that that was not the law. It was just for political convenience. And when political convenience failed, everybody will resort to what is right, and that is the law. And to me, the 2024 budget has been duly passed and is in operation. And in short, I learned the governor is already presenting that of 2025. The state will move on, and any call for anarchy should be resisted, because that is what the Martin Amaewhule-led government is trying to do.
Led House of Assembly.
Yeah, led House of Assembly is trying to do by calling for lawlessness.
Okay, now speaking about the law, you said when political solution has failed, the right thing to do is to do the right thing, which is what the law has said. Speaking about the law, are you aware of any judgment by a Federal High Court judge, Justice Omotosho, annulling the presentation of the appropriation bill to Edison Ehe? Are you aware of that judgment?
Okay, are you also aware of a court judgment barring the governor from representing, interacting, interfacing, and dealing with the Martin Amaewhule-led government? Are you aware of it?
Barrister forgiven.
Yeah, that's what I'm saying, that the governor is operating within the...
When was this judgment you talked about? When did it happen?
However, or whenever it happened.
In the order that it happened, when did it happen?
That is a subsisting order, except the one the governor
there was a judgment.
to disobey.
Hold on. There was a judgment.
Yes, and there was an appeal.
Order.
And there was an
appeal.
appeal.
An appeal court?
Yeah, you people keep no. What I'm saying, not to you. Let me come. Right. You know, because I'm just coming from your sister radio station, and they keep on. What he also said is what this is a judgment. This an order. So and as such, the judgment should take precedence over
I asked in the order that it was given.
Yeah.
And then the second question I asked is, which court set aside the judgment of the Federal High Court?
I said that is on appeal. But there is a subsisting, the one of the Federal High Court is on appeal, but there is a subsisting order.
From what court?
From a state high court.
From a state high court?
Yes, which has coordinate jurisdiction with that of the Federal High Court. They are equal.
That is left for the Supreme Court to decide.
Yeah.
Whether the state high court actually has the jurisdiction, actually. Yes. We are not talking of coordinate jurisdiction. Yeah. We are all aware that federal and state, but in the matter of legislature and the governor, the appeal court in their judgment has said that the state high court do not have jurisdiction to entertain legislative matters and matters pertaining to the executive.
But that's not true.
That is what is being appealed.
No,
you can tell me for the I asked you a question before Barrister Sim will have his say. Yeah. Now, I asked you if there was a judgment that nullified that presentation of appropriation bill, and in that judgment, the governor was ordered to represent the bill. Yes. Now, you are answering that there is a court order that barred the governor from doing so.
Yes.
And I asked again, what court? You said the state high court.
Yes.
That's on one side.
Yes.
Now, the second one, there are courts of coordinate jurisdiction. Now, in order, in the order that it happened,
in order of precedence,
which one takes preeminence?
No, the one of the federal high court of Omotosho came early, but mind you that before Omotosho, there were other judgments. There was the Edison Ehe judgment that did not recognize them. So Omotosho came between. So do you want the governor to jettison that one and obey that of the Omotosho's court? Then to strengthen that, a state high court also categorically say we are barring you from entering until the Court of Appeal or the Supreme Court interprets otherwise. The balance of convenience will be for me to obey the one that I should obey, because there are conflicting judgments.
Like you said, balance of convenience is to obey the one that is convenient.
That I should obey. Yes.
Now, You talked about the one of Omotosho,
Yes.
that it came earlier. However, there was another one.
Yeah,
correct?
we are before
And the
before that one.
governor
Yeah.
is at liberty to follow the one that is convenient for him. Now, are you aware that to a large extent that the governor followed the order of Omotosho? Because after he presented appropriation bill
Yes.
to the Siminalayi-led House of Assembly,
Yes.
he came back to the Martin Amaewhule-led House of Assembly, where he presented some names for screening and subsequent appointments. He also presented some executive bills to the Amaewhule-led House of Assembly. This was after he presented the appropriation bill to the Siminalayi-led House of Assembly. The governor, in his actions, by the reason of his actions, recognized Martin Amaewhule after he had his dealings with Siminalayi and he had dealings with Martin Amaewhule. So when you say it's a function of convenience, one would wonder.
Well, I have told you. That don't forget that before Omotosho, there was the judgment recognizing a year.
So why did the governor obey the judgment of Omotosho?
When you are saying, Lawrence, let me talk
go
now.
on, sir.
You always you spoke and I listened. You are saying things that we are not okay by me, but I listened to you.
Right.
So now before Omotosho, there was the one of Edison recognizing Oko-Jumbo and the rest, and the recognizing Amaewhule and the rest and his people. Now, I told you that the governor did what he did, not because it was the law. It was political intervention, the political solution, and not the law. That was why it was after the presidential intervention, in his spirit of a settlement. Let's live peaceable. Let's live. Let a problem go. He went back to recognize them, but because of recognizing them, he saw that they were not willing. They were not. They didn't have the spirit of give and take that he had. They were not disposed to making peace. So he had to withdraw. It was stage by stage. He was doing all that because of political convenience. So he didn't do that because he knew that they were recognized by law. It was out of political convenience, political settlement that failed.
All right. Barrister Sims, what is your take on this issue?
Well, thank you very much. I listened to my colleague and I listened to you also with rapt attention. So I'm not going to be attacking the opinions of my colleague or that of yours. I'm going to give my own opinion because we have our rights as laudable to air and give our opinions. Now, on this particular River State imbroglio, the Wahala, I found out that the executive arm of government, with due respect, is playing what we call boju kind of politics. You know, in those days when we were younger, there's this play by moonlight that we normally do as young kids, and one of them was that you tie the eyes of one of those who are participating in the play to locate something and be looking for it in the dark. Only those who kept it somewhere know exactly where that particular treasure was hidden. So you might just ruminate and go around, dwell in the dark and go around, you might not locate it except by luck. The second one is this. The government or the executive arm has decided to operate a government of selective amnesia. That is, selecting which one will benefit you, which one will not benefit you, you go with it. And he goes further to elucidate that politicians, with due respect to them, just like Abatistin said, that truth, they say the truth only when it is convenient to them and it will help them. That is my take. Now, coming to the legal, or let me say the trajectory of what has been going on. You know, soon after the legislature had their issues, upheavals, there was a reported bomb blast in the assembly compound, which necessitated the governor to come out, and we all watched what happened, unfortunately, on television. Soon thereafter, a matter was filed by the state government as at that time before the state high court. I think Dan Agogo was the judge. I think Dan Agogo was that judge. Surreptitiously, while we were trying to fathom out who may have gone to bomb the assembly court hall or the hallowed chambers, a court order came out from Dan Agogo. I think that should be Justice Dan Agogo. An ex parte order restraining whoever 27 members it is as case may be, and said Edison here is an authentic speaker of the house, and that these other people have defected etc. as case may be. That is known fact. The other people, the other 27 or thereabout, while that ex parte order was issued, they went to the Federal High Court in Abuja to challenge Edison here or any institution at all, declaring their seat vacant, and that they cannot perform, you know, the duties of the Legislative Assembly. I think that court gave a judgment. It was not a ruling, it was something other, it was a judgment, a full judgment. How did that court give the judgment? Was that before you knew what was happening, like abracadabra that normally happens in Rivers State these days, Edison here left the position of speakership and now became the CS, or whatever they call COS, or whatever they call that position. I think chief of staff to governor, and surreptitiously also withdrew, you know, their case because they were supposed to defend that particular Federal High Court case before Motosho. They withdrew. I think the state government also withdrew their own, defense or whatever. I don't know what played out. The plaintiffs or claimant in that particular issue, which is the 27 lawmakers, did not withdraw their own. Omotosho now went to give a judgment and stated that the defendants, having withdrawn, their defenses, means that they have no defense to the claims of the claimants or the plaintiff, and I gave a judgment toss that for withdrawing it means that they have accepted and admitted the averments of the plaintiffs or claimants, as you call it, that is the 27 lawmakers. Mind you, in that particular suit, a lot of reliefs were being sought by the 27 lawmakers because you had about 18 defendants in that case, in that matter, including the Speaker of the House of Reps, President of the Senate, AGF, then the AG State ETC, Governor ETC here, and the rest of them, just lined about 18 of them. So the plaintiffs, amongst other claims or reliefs they were seeking, the Federal High Court of Motosho to give to them is number one, that the budget passed by the 5-man assembly led by Edison here, as at that time, should be declared null and void, and it was not presented to a proper House of Assembly. The second one was that that the state government or anybody at all should not interfere with their sitting in anywhere in Rivers State to hold and perform their legislative functions. 3, that the governor, because hitherto was not paying them as their emolument CTC, or he released part of it, that the governor or the executive arm of government must do what? Pay them their emoluments monthly. Among other ones was that the clerk of the house, I forgot, I think he said doing something. It was the clerk of the house that who was transferred. I think the governor had to transfer the clerk to another, they deployed him to another department. The court amongst others says the governor of any state at all does not have such rights. Even though the clerk of the house is a civil servant, his election or removal is done by the House of Assembly of his state, not just Rivers State, all over Nigeria. Amongst other issues, I think about 8 reliefs they were seeking. Among other one was that the governor of the state, Rivers State, should not make laws as by way of executive orders that will affect whatever it is as the case may be. Then so many other, because of time. The court, Omotosho court came and said, no, you cannot restrain the governor from performing his executive duties under Section 5 of the 1999 Constitution, and struck that one out of their reliefs. But all other reliefs were granted by virtue of the fact that these people withdrew their own defense voluntarily and willingly. And my colleague here knows that if you put in the affidavit and you have to put a kind of indemnity that if I present facts that are false, it is as the case may be, this is how much I should pay co-founder, or maybe one thing happened, a fine was sort of put there. So this was what happened. So it was based on that particular judgment of the Omotosho Federal High Court that the 27 lawmakers ran back to Port Harcourt and they started doing what they are doing right now, sitting, doing everything. And mind you, the Omotosho High Court judgment still has currency and it's still subsisting because it has not been set aside. It has not been vacated. Whether he made a rightful decision or wrong decision, etc., you have the way to go on appeal. It has not been decided. No appeal has been reached or taken. The point is this: why that is subsisting. The legal question to be asked is that if I voluntarily withdrew my own, averments and claims, and the court now goes ahead to give decision against me, after I've withdrawn voluntarily, nobody forced me, do I still have that right, proprietary right, to appeal that particular decision of the court? I'm sure that is the dilemma the governor's side and the here side, have. In my own opinion, I think that is the dilemma, because they feel that if we appeal this Omotosho, because it's a very simple thing, is as Jumbo appealed the Court of Appeal, I believe they would have gone to set aside that Omotosho judgment. Now, coming to play into the span as the case may be, Oko-Jumbo now came because there was little peace from December, mind you. This particular DC was passed to a year. Among others, the court also ordered that the budget of 800.3 billion naira that was, the appropriation bill of 800.3 billion that was presented to the here-led House of Assembly before he resigned and left was null and void, and ordered the government of Rivers State or the governor to represent that particular bill to the House of Assembly. And that Federal High Court of Omotosho said that of Martin Amaewhule. The judgment is there. You understand? Now, all these things were not done. People say, no, he cannot represent. People, Saribe went to court and got one senior advocate, Kayode Ajulo, to represent them at the Federal High Court in Abuja. Labour Party also joined in that particular suit at the Omotosho Federal High Court, that there are parties interested, and they were also joining forces with the government and other ones on the other side, that these 27 lawmakers have lost their seats and therefore they cannot perform legislative functions. Labour Party joined that suit. Federal High Court, Omotosho. You know what happened? Before the judgment could be given, Labour Party had a terminal orgasm, and what they did was to go and withdraw their matter again. They withdrew their matter. They now left that of Sari Igbe and his group, the other Ankyo Briggs, that now went to another court in Rivers State here. Justice Wogu said, no, we don't have jurisdiction on this matter. They now appeal that Justice Wogu whatever. So in essence, going through this gamut and this trajectory of explanations is for us to get a grasp of what is happening. So going through this whole thing now, legally speaking, can Oko-Jumbo and the speaker now say that the sitting of these people are illegal when the court in Omotosho's case has not been vacated, no appeal has been taken? That's number one. And the Court of Appeal said the lower court lacked no jurisdiction. Therefore, all parties should go back and be doing what they were doing before, because this particular 27 are operating on the pedestal of the Omotosho court decision. That is what they are operating on. So can this present speaker come to say that they don't have the legal right or locus to begin to sit? For me, I am unbiased at this point in time. For me, I don't think he has that premature authority to speak and declare that particular seat or whatever happened. What is happening in Rivers State today is a constitutional crisis brought about by a political misunderstanding. You understand? And it may linger for a very long period of time. Finally, if the government decides, because of course he will decide, he can't choose his enemies to come and take whatever his case may be. He will decide and be floating with the Oko-Jumbo 4 or 3 members of the House of Assembly. And that is his own right. But because you have done a thing beautifully well, but it's a wrong method and a wrong thing, does not make it legal. You have the strength, and that goes to echo and reiterate what Bill Clinton said some years ago, that Africa, the reason why we are backward is because that we have strong men and not strong institutions. If we had strong institutions and weaker men, the rule of law should have operated. I believe that the just amount of sure judgment should have been followed, because a judgment for me is far thicker and superior to an interim order, which is an order that has a lifespan of 7 days. After 7 days, the court cannot sue motu, reignite or revitalize that particular order. The parties have to go and apply to revitalize the order. And in this case, that Agogo's order, I beg to know, maybe I don't know much, whether the parties went before the Agogo after 7 days, he gave that order, bringing in a year, whether they've gone back there after a year exited, to go and reincarnate that order, and maybe resurrect that order like Jesus Christ. I mean, I want to know all these things, because it's something I don't really understand. So please, let me end it there. I just, because the Rivers matter is becoming something, I thought we were going to discuss some other things today, but no problem. Let's discuss Rivers.